What happens if you pass away without any sort of estate plan, no trust, no will, nothing set up whatsoever? The state tells us what happens to all of your property. My name is Michael Pevney. I am an estate planning lawyer in Southern California. I practice all over the state of California. You can find out more information about me in the comments and set up a time to meet with me for free to discuss your estate planning options. So, if you have no estate plan set up, here's essentially what happens. First, we have to figure out if you are married or not, because that makes a big difference. If you are married, we have to divide property into community property and separate property. Community property is any earnings of either spouse, doesn't matter who makes more than the other, during the time of the marriage. So that is all community property. All of your community property will go to the spouse. Then we have separate property, and then there's a difference between separate property and community property. Separate property is all property that you earned before the marriage, or something that you received as a gift is during the marriage is separate property, or an inheritance that you received is also separate property. And then what happens with your separate property? You got to make a determination. Well, first, are there kids? If you have kids, then half of the separate property goes to one child, if you have one child, and then half goes to the spouse. And then if you have more than one child, 2/3 of that separate property goes to those children. 2 or more children, doesn't matter how many kids you have. It's got to be at least 2, though, for it to be 2/3. And then 1/3 of that separate property goes to the spouse. What if there are no kids? Then we've got to use this chart here. So if you're married and you have separate property, or you're not married at all, this is the chart that we use, and this is what has to go through court, and we have to figure out and do an entire family tree of where your stuff is going to go. So this is where all of this comes in. This is the chart that is actually published by the state, and you can find it right there. It's called a table of consanguinity. So consanguinity is one of these law school words that we all learn. Consanguinity is basically bloodlines. So we're talking about people that are either natural or adopted, parents and children, and siblings of those parents and children, and we get into grandparents and grandchildren. So let's just say if somebody's single, what happens to their stuff? Well, first, so here's the person. Here's you if you're single and you're gone. So you've got the person. If you pass away, things go to the children. If you have children, none of them are alive and they've passed away, then they're going to go to grandchildren. If you have had children and grandchildren, but they're both gone, and you have great-grandchildren, then that property is going to go to the great-grandchildren. If there are no children or anybody else in your own bloodline and you have living parents, then it's going to go to the parents. If you have none of that, then it's going to go to the children of the parents, which are, of course, your own siblings, your brothers and sisters. And then beyond that, if none of them are around, then we go to nieces and nephews, and then we go to grandnieces and nephews, and all the way up the chain to eventually, when we have grandparents, if there's nobody else around, grandparents, aunts and uncles, first cousins once removed, all of this, and then we keep going and try to find people that are alive that fit somewhere into this chart. So eventually we go to grandparents and then descendants of those grandparents, which are often going to be great aunts and uncles, first cousins once removed, second cousins. By the way, this is a great chart to tell you exactly what a second cousin is and a first cousin and the whole once removed thing as well. So we go to second cousins once removed, and then finally, we get to great-great-grandparents and all of their descendants. Very unlikely that your great-great-grandparents are alive, so we're probably going to be going down the chain here. This is if essentially nobody else in any of this chart is living. So eventually, we get to third cousins. So the question is, Do you know who any of your third cousins are? Now you might have a super tight family that's kept together, and you know who all of them are because everything's going to be sort of split between all of them, and it goes all the way down to as distant as third cousins thrice removed. So eventually, if you have none of these relatives and you're unmarried, or your separate property, if you are married, goes to all of these people. And then finally, if you don't have any of these relatives at all, that property is going to, the word is escheat, all right? ESCHEAT, escheat. That means it goes to the state of California, or whatever state you live in. There is some process by which, if there's no living relative around, that's where the property goes. So this is what happens. These are the calculations and the machinations and everything that gets involved if you pass away without any kind of an estate plan, a will, a trust, and all of this gets hammered out in court. There are often investigators that have to be appointed, or the lawyer has to hire an investigator to basically figure out your family tree and figure out where all of this stuff is going to go. So what's the solution to this? What is the better and much, much better idea? Is to have an estate plan. At the very least, a will. If you live in California and you either have kids or own any real estate, I'm usually going to recommend a trust, a revocable living trust for those people, those clients, over a will for 4 specific reasons. First, it avoids probate, which is the entire court system you get to avoid. It's very expensive, often costing people in my area about $50,000. By the way, it doesn't cost them, my clients, $50,000. It costs the people that they leave behind that are not going to inherit that. Second, control. So we want to have to avoid this entire chart, right? And especially, let's say you're in a committed relationship and you are not married, whether you have kids with that person or not, that significant other they get absolutely nothing. So we want to control where everything goes. It is very, very likely that there is someone out there in the world, whether that's a close friend or a romantic partner or a charity, that you would rather inherit your property than a third cousin that you've never met before and have no relationship with, and you've probably never even heard of them. Third reason why a trust is oftentimes better than a will: privacy. When things have to go through probate, that is a court system, it is a set of court hearings, and technically it's open to the public. Whether you've heard about Prince or Aretha Franklin or Philip Seymour Hoffman, all sorts of people that didn't have appropriate estate plans set up, all of that has to go through court, which is why we know about everything that happened to them and their ultimate estate plans. And then the fourth reason why a trust is ultimately going to be better than a will is time and hassle. In California, it often takes 1.5 to 2 years to get through this entire court system. If we are having to identify third cousins, and we're talking like there's plenty of people that are not in this country that are third cousins or third cousins thrice removed, very likely in your family, and someone's got to find them and track them down to get their inheritance to them. And so we don't want to have to go through that amount of time and that amount of hassle in order to do that. So the solution to all of this is, of course, to set up an estate plan. A will is much, much better than nothing, although it still does have to go through probate. For most of my clients, I do typically recommend a trust, a revocable living trust. And then a complete estate plan is always going to have some other important documents associated with them, like a power of attorney where you are alive but somebody's able to take over the finances, maybe if you are incapacitated, or maybe if it's just inconvenient for you. We always want some sort of advanced healthcare directive laying out what your end of life decisions are. Certainly if you have kids that are under 18, we want some sort of a document laying out who you want to be their guardian should both parents pass away. We always want final wishes and burial instructions so nobody's basically fighting over what happens to your body after you are gone. So this pretty much lays out what happens to your stuff. And this is for the state of California. Many states are a little bit similar. They do the best they can based on relations, knowing and understanding that they have no idea what you want to happen with things, so they create this thing, a table of consanguinity, laying out who's going to get your stuff, going all the way to third cousins thrice removed here if we can't find anybody else to inherit your stuff. So once again, my name is Michael Pevney. I'm an estate planning lawyer in Southern California. Obviously, follow and subscribe to this page if you'd like more estate planning content. I am on most social media platforms with plenty of followers and subscribers. If it's time to set up that estate plan and you live in California, you can set up a time to speak with me for free by following the link in the description here. So thanks for your time and thanks for your attention.